the 4th Estate. The petition by the 4th respondent before the Assembly did not meet the threshold of removal of members of the Kakamega Public Service Board under Article 251 of the Constitution. The signing or affirming of the report by the Assembly members who are not at the hearing was unlawful. An order of certiorari is hereby issued quashing the report of the Assembly Committee dated 11th December 2023 and the consequential decisions including the resolutions of 14th December 2023 of the respondent communicated by letters to the petitioners dated 15th December 2023 removing them from office. The first, third and fifth respondents are restrained from relying on the letters dated 15th December 2023 communicating removal from office of the petitioners. The petitioners are to resume office with immediate effect and serve for the remainder of their term unless lawfully removed from office. The petitioners are awarded each Kenya shillings 1 million for violation of their rights plus costs. Money is awarded to attract interest at court rates from the date of judgment if not paid within 30 days of the judgment. Upon delivery of the decision, Mr. Luther Counsel for the first, third and fifth respondent made an oral application for stay of the order. The petitioners to resume office with immediate effect and serve for the remainder of their term unless lawfully removed from office to enable them appeal. The application was opposed by Mr. Shifoka for the petitioners on grounds that the court, having determined there were illegalities in the removal of the petitioners from office and violation of constitutional provision, it would be a shot on its own arm to stay its decision. It would be tantamount to sitting on an appeal. Given the uniqueness of the case, it would not be in public interest as the public had been denied service of the board since 14th December 2023. Decision. Delivered a judgment dated 6 June 2024, allowing the petition dated 14th December 2023 as follows. It is hereby declared that the removal process of the petitioners from office by the Kakamega County Assembly, the second respondent, was in violation of Article 35, 47, 50 and 236 of the Constitution. It is declared that the rash proceedings with the petition notice to the petitioners before the Assembly and the removal of the petitioners from office was unlawful. The petition by the fourth respondent before the Assembly did not meet the threshold of removal of members of the Kakamega Public Service Board under Article 251 of the Constitution. The signing or affirming of the report by the Assembly members who are not at the hearing was unlawful. An order of certiorari is hereby issued quashing the report of the Assembly Committee dated 11th December 2023 and the consequential decisions including the resolutions of 14th December 2023 of the respondent communicated by letters to the petitioners dated 15th December 2023 removing them from office. The first, third and fifth respondents are restrained from relying on the letters dated 15th December 2023 communicating removal from office of the petitioners. The petitioners are to resume office with immediate effect and serve for the remainder of their term unless lawfully removed from office. The petitioners are awarded each Kenya shillings 1 million for violation of their rights plus costs. Money is awarded to attract interest at court rates from the date of judgment if not paid within 30 days of the judgment. Upon delivery of the decision, Mr. Luther Counsel for the first, third and fifth respondent made an oral application for stay of the order. The petitioners to resume office with immediate effect and serve for the remainder of their term unless lawfully removed from office to enable them appeal. The application was opposed by Mr. Shifoka for the petitioners on grounds that the court, having determined there were illegalities in the removal of the petitioners from office and violation of constitutional provision, it would be a shot on its own arm to stay its decision. It would be tantamount to sitting on an appeal. Given the uniqueness of the case, it would not be in public interest as the public had been denied service of the board since 14th December 2023. Decision. The ground of stay of decision of the court pending appeal is per section 42 of the civil procedure rules. And I have cited that. I will not read. Parties can always read for themselves. The court appeal in National Assembly and 47 others for Koiti and 169 others. It's a recent decision of 2024 in terms of citation under EKR. Considered an application for stay of decision of the High Court related to degradation of constitutionality of a law emanating from the National Assembly. The Court of Appeal in their aforesaid decision pronounced the applicable criteria to apply in a determination of application for stay pending appeal. That would be in paragraph 1 to the effect that an applicant who would succeed upon such an application for stay of execution must persuade the court on 2 limbs. 1. That the appeal or intended appeal was arguable and not frivolous. 2. That if the application was not granted, the success of the appeal, were it to succeed, would be rendered negatory. The court then said those 2 limbs must both be demonstrated, and it would not be enough that only one has been demonstrated. I applied the decision in this my decision. I pronounce myself and declare the decision to remove the petitioners from office by the County Assembly to be unconstitutional, unlawful, and attended with illegalities. How then can I decide there is an arguable appeal without doubting my own decision? I agree with the petitioners that I will be sitting on my own appeal. The Court of Appeal in the same case which I cited earlier in paragraph 14 said the presumption of constitutional validity in respect of the impugned sections was extinguished the moment the trial court issued the declaration. It would not be in public interest to grant a state whose effect was to allow a statute that had been found to be constitutionally infirm to continue being in lawful pending the appeal. I uphold and apply the decision to find that, having declared the impugned decision of the County Assembly of the removal of the petitioners from office unconstitutional and unlawful, the presumption of constitutionality and lawfulness of the County Assembly processes and resolution was extinguished, and the order of stay, if granted, would be tantamount to enabling further violation of the petitioner's rights. The court further holds that it is not in public interest to grant the state so, as the board functions have been held in abeyance since 14th December 2024, and the people of the county of Kakamega were entitled to its statutory services. The application for the stay of the court order of reinstatement to the office of the petitioners with immediate effect is disallowed. Right to appeal. The decision is available and will be published in the next 5 minutes.
The petitioners, who are members of the Kakamega County Public Service Board, were supposedly removed from office. The decision of the court this morning affirms the faith and belief that we had that the process had been flawed, there was no valid reason, and all actions and processes were geared towards political preferences and biases. Even after the decision had been delivered, confirming the various violations that were subjected against the petitioners, the part of the respondents, particularly the first, second, and fifth, sought to have the decision stayed. And we are glad that the court has confirmed that staying the decision would not be, one, in public interest, and it will not be consistent with an already decision and findings of the same court. And we are hoping that once the team gets back to office and constitutes a lawful quorum, they are going to review all these actions and come up with what is a procedural, substantive, and valid cure to those political actions that have been undertaken while they were out of office. We are hoping that we shall see harmony and unity continuing to exist, or rather recreated for the purposes of running the government and ensuring that the service sector, the employment sector of the county is not interfered with.
Members of the fourth estate, good. Wengine watamkaza.